to welcome everyone of you who has logged in. Today's session is going to be a discussion hosted by Kenya Cybersecurity and Forensics Association to simplify cyber laws in Kenya in a way that can be understood by those who are not lawyers and those who are not in the cybersecurity or related fields. And I am going to be your moderator today. I am Rehema Mutunga. I am an advocate of the High Court and the Secretary General for Kenya Cybersecurity and Forensics Association, which is kind of hosting this this whole webinar. And I think I will just go straight to the point. I see people are still joining in, which is good. For those who are going to join in after we've started, they'll find us on the way. So I would like to welcome our panelists who are going to take us through the discussion. And I'm going to make a brief introduction for each one of them. Our first panelist is Ms. Nzula Kioko. She's an advocate of the High Court of Kenya with a keen interest in technology, media, and telecommunications. She has over 5 years in the technology industry, and she works with Ashitiva Advocates. We also have our second panelist. Has he joined yet? Our second panelist is going to be Mr. Kingori Mathenge, who is a digital forensics researcher at Ekraal Innovation Hub. I hope I've said that correctly. And our third panelist is going to be Mr. Thomas Chiteri. Thomas Chiteri is business coordinator at Isuzu Kenya, and he's a special member of Kenya Cyber Forensics Association, and he's also he has a Bachelor of Science in Telecommunications and Information Technology with many other certificates, MCSE, and yeah, so those are our three main panelists who are going to take us through the discussion today. So I will dive in into the heart of the discussion today, and I will go to our first panelist just to open this discussion. For Ms. Nzula Kioko, could you please take us through the laws governing cybersecurity in Kenya, and just tell us your opinion whether these laws are adequate? I'll give you 10 minutes or so to take us through that.
Okay, thank you very much, Rehema. I will take you through the laws, and could you kindly share my screen so that I can share my PowerPoint presentation for tonight. The laws governing cybersecurity in Kenya are, for instance, one, the Kenya Information and Communications Act, Cap 411A, and the Kenya Penal Code. However, these regulations, which had already criminalized several cyber crimes, and the provisions of these laws have been superseded by the Computer Misuse and CyberCrime Act, which was enacted in 2018. That is when it was signed into law. Part 2 of the Act, I'll just go straight into the Act, and I'll also be talking about some of the major crimes that have been described in the Act as a way of introducing the topic to the team and everyone who's listening. Part 2 of the Act talks about the computer misuse, establishes the National Computer Cybercrimes Coordination Committee, whose purpose is to do various things, one of which being advise the government on security-related aspects, touching on matters relating to blockchain technology, critical infrastructure, mobile money, and trust accounts. Also advise the National Security Council on computer and cyber crimes. It's also supposed to coordinate national security organs in matters relating to computer and cyber crimes. Also, it's supposed to develop a framework to facilitate the availability, integrity, and confidentiality of critical national information infrastructure. But one thing we need to note is that this committee, though has been talked about in the Act, has not yet been set up, though the Act was passed in 2018. We are still waiting for this committee to be set up. Among other functions is also to, they're the ones who are supposed to develop and manage a national key public infrastructure framework, develop the framework for training on prevention and mitigation of computer and cybercrimes and matters connected thereto, and any other purpose that the law might require them to do that. To do so. Now, the criminal activities under the Act, the first major one, of course, is hacking, and hacking as an offense is usually committed when a person, whether temporarily or permanently, causes a computer system to perform a function by infringing security measures with intent to gain access without authorization. And the punishment for this is a fine not exceeding 5 million or imprisonment of up to 3 years. The second offense under Section 15 of that Act is to unauthorized access to commit a further offense. Here, the penalties are a bit steeper. It's a fine of 10 million and imprisonment of 10 years or both, depending on the crime that has been committed. Then there's also another crime that has been described in that Act, which is phishing. This is described as opening or operating a website or sending a message through a computer system with the intention to induce the user of the website or the recipient of the message to disclose personal information for an unlawful purpose or gain. The information may be used to grant one access to a computer system. This is, for example, what our guys at committee have been doing. When they call you, they ask you for information and you give them your information, and then they end up hacking your M-Pesa and withdraw money from your account. Now, this offense is punishable by a fine of not exceeding 300,000 or imprisonment for a term of 3 years or both. Then another crime that has been described under the Act is the injection of malwares into IT systems. Also, the possession and use of hardware and software tools that may be used to commit cyber crimes. For example, hacking tools. Here, the penalties are very steep. And if you're found guilty, you'll be liable to a fine not exceeding 20 million or imprisonment for a term not exceeding 10 years or both. Now, there's also another crime, which is identity theft and identity fraud with the use of access devices. Identity theft and impersonation occurs when a person fraudulently and dishonestly makes use of electronic signatures or passwords or any other unique identification measures of any other person. Liability here is a fine of not exceeding 20 million, but the imprisonment term is about 3 years, and you can get both, depending on what the magistrate or the judge who's handling the matter. Then the other thing is electronic theft, where there's breach of confidentiality by a current or former employee. Here, where there's breach of confidentiality by a current or former employee, it might not attract criminal liability, but you might sue the former employee under civil proceeding for breach of contract. But if anything is stolen in the process, then the person may be liable to a criminal conviction of not exceeding 3 years. Now, there's also the unauthorized disclosure of passwords or access code keys knowingly and without authority. This one attracts a penalty of 5 million or imprisonment of 3 years or both. There's also the failure to implement cybersecurity measures, the ones that are supposed to have been prepared by the committee under Part 2 of that Act. Now, since these laws are still not yet in place, it will not attract any criminal offense, though they're supposed to come up with strict measures for adherence. Now, another offense I've come across while I've been doing my reading is obviously cyberbullying. This is bullying that takes place over digital devices like cell phones, computers, and tablets. Cyberbullying can occur through SMS, text, and apps, or online or social media forums, or gaming where people can view, participate in, or share content. Cyberbullying includes sending, posting, and sharing negative, harmful, false, or mean content about someone else. It can also include the sharing of personal or private information about someone else without causing embarrassment or humiliation. Some cyberbullying crosses the line into unlawful or criminal behavior, depending on how it is being conducted, and Section 27 of that Act, of the Cybercrimes Act, deals with this, and it states that the person is punishable to a fine of not exceeding 20 million shillings, or to imprisonment for a term not exceeding 10 years. So I think those are some of the things that we need to be looking at. And the other one, unfortunately, in my opinion, that provision is very vague. As one, the Act does not define what cyber harassment is, and two, it does not contextualize the crime. Three, it also provides for punishments that would have been chilling effect on the right to freedom of expression. However, it's only legislative provision that deals with cyberbullying under the Kenyan laws. Yeah. So the other thing that I've come across is what we call revenge porn. The dictionary definition, I think everyone knows what it is. It's the revealing of sexually explicit images or videos of a person posted on the internet, typically by a former sexual partner without the consent of the subject and in order to cause them distress or embarrassment. How Kenyan law per se does not specifically deal with this kind of revenge porn. Nonetheless, several provisions of the law may be applied by persons aggrieved by revenge porn. One, where the images are of a public figure with image rights, they may sue the infringing party for using their images without their consent. But it is important to note that the concept of image rights is not well defined also under Kenyan law. The second way one can deal with this is also one may sue for defamation depending on the context and the images that are shared. The defamation suit is basically to protect the reputation of an individual. That is also covered under Article 33(3) of the Constitution, that provides that in the exercise of the right to freedom of expression, every person shall respect the rights and reputation of others. 3, one may sue for breach of privacy under Article 31 of the Constitution. 4, where also intimate images are shared with persons below the age of 18 years, the Sexual Offences Act can also come into play, and Section 11 of that Act will be of particular use in that regard. Now, yeah. So what I've also come across with regards to that law is that it has the extraterritorial application. That is when you use it in line with the Mutual Legal Assistance Act of 2011 and the Extradition, Contiguous and Foreign Countries Act. That means that if an offense is committed under the Kenyan territory, a requesting state may, through the AG's office, request to conduct investigations and collect evidence for that case, and they may be tried in the foreign country if the AG's office accepts. And the same can apply vice versa, where we as a country through the AG's office can request for information where a crime has been committed. Now I'll go on to under this act also there's no mitigation of any penalties that have been issued. However, under the Kenyan criminal procedure system, it provides for mitigation, and in that, when you use that law, then you can be able to apply for mitigation under one of the when it comes to the harsh sentences that are given under the laws. Now, the question that you've asked, whether these laws are adequate, in my opinion, I feel like the act is too vague when it comes to important details, particularly those that deal with the issue of surveillance. The act also criminalizes the publication of online or false information or hate speech, but it does not explain what hate speech entails. In fact, the definition given in the act is very vague and does not give proper parameters for determination of what hate speech is, and that is left actually to human interpretation, which I don't think is appropriate. The other thing is that the act criminalizes false publications, but it offers no related definition of this. That's another issue with definitions that have been given in that act. So I feel like these ones need to be amended to be very clear so they can be able to adequately address the issues. Then there's also the issue of the act does not state how one can go about reporting what a cybercrime is, and it doesn't give the body to where one can go and report these crimes. So as it is, we're just left to the general justice system as it is. And I think that's I think I've come to the conclusion of my presentation, unless there are specific questions. Hello?
Thank you, Nzula. Now, I think for everyone who has any question, you can kindly send to info@kcsfa.co.ke, or you can just chat them in on the KCSFA team. You can see them on the participants panel. So thank you very much for that presentation. Now, questions, we'll deal with the questions later. Now we will go to our third panelist, Thomas Chiteri. And Thomas, what I would want you to discuss after this discussion of what are in Kenya on security. How are those laws applicable in the corporate environment? And in your opinion, what likely improvements would help improve ease of business? Because I think when you talk about the Computer Misuse and Cybercrime Act and any other touches on cybercrime and cybersecurity, of course, the corporate environment is usually affected because they're carrying on business, and business can be affected by lapse in cybersecurity. So could you just take up the discussion?
Okay, thank you, Rehema. Thank you for the opportunity. Actually, the computer misuse and cybercrime, as much as most of the Kenyan citizens take it as an individual level-based law, this law is going to really affect the corporates from the employer perspective and the employee perspective. And maybe Rehema, if you could just allow me to present something on screen, friendly.
Yes. Yeah. Please go ahead.
Okay, so if we look at the corporate perspective, I want us to focus more on the employee and the employer himself, their responsibilities and where they are going to be affected on this particular computer misuse and cybercrime law. And I'll start from the employee perspective. We have several sections from the cybercrime law that are going to fully, directly or indirectly affect the employee, and they need to be very much aware of that law so that by the time it's coming there, as they say, ignorance is not an excuse for the law that has already taken place. And if we check on section 14, section 15, section 17, and section 21, they have talked about, the Act talks about the unauthorized access. And in the Kenyan corporate world, unauthorized access does not necessarily mean that this person is an external person from the company who is accessing our information. Most of the time, people who are entrusted with the opportunity to take care of the information and data within the company are actually the people who are at great risk to be the people who are going to misuse this information. And I'll just give you an example. For example, people who are in information technology for different corporate IT departments, you find these people have been given a mandate to access different information at different levels, but that does not necessarily mean that you are now allowed to use that information for your own personal gain or to help somebody else to be malicious against the company. That is what we are talking about, the unauthorized access. And most of the time, that is an offense. And even if you go further to section 15, it also says, apart from having the unauthorized access to that information, you can also access the information and use it further to commit an offense. And that is another offense on its own. So these are some of the things that people need to know as employees when they are dealing with information entitled to them during the employment period. The Act also talks about interception, and interception is very common in most corporate organizations, especially where email communication is the official way of communication. You find somebody is trying to intercept that is meant for the managers, maybe to get to understand what exactly these people are trying to communicate or to discuss. and use the same information maybe to give it to a third party to perform whatever they want to perform with that information. That is a crime on itself, and you can see from the Act that these are crimes that are punishable by a jail term not less than 5 years, and even a fee of 10 million or even both. And then the Act also talks about cyber espionage. And here is where most managers, for example, in a corporate, because they use their position and their office. They misuse their office, their position, to tell the juniors to do a certain thing, maybe based on the computers, to gain access, to help them deal with some aspects in that organization. That is wrong in itself, whereby you are using your authority, you are using your position in a company to make another junior staff to gain information that will help you to do other activities that are illegal in that particular organization. And that tells you that that is a crime on itself, and it's an offense punishable according to this Act. And then now when we go to the employer perspective, now the employer himself, we have sections that are actually touching on the employer. And if we look at Section 28, Section 29, Section 36, Section 41 and 43 of the Computer Misuse and Cybercrime Act, where we are talking about cyber squatting. Cyber squatting under Section 28, it looks at an organization which tries to impersonate another organization in different forms. One, either using another organization's name to in its business dealings, or using the trademarks, the logos of other organizations without the authority of the owner of that particular organization. That is a punishable offense according to this Act. We are also looking at identity theft and impersonification, whereby you find for those organizations which have fully automated their processes, and we have workflows in that particular organizations where a process is moving from one person to the other person, we have people who want to go against that by using other people's signature to approve a certain process at their stage without the other person knowing. So that is an offense on itself that the employers are supposed to be aware of. And then most organizations, especially the HR departments of most corporate organizations, have come up with what we call the information lifecycle management, whereby we have certain electronic information that is not supposed to be damaged before their term expires, and especially that information that is normally used for legal purposes, like the tax returns, the service level agreements, confidential information that can be used later on as evidence in a court of law. If you unlawfully destroy this information before their lifetime expires, then you are also committing an offense as an organization. Then lastly, we can also look at the offenses by a body corporate and limitation of liability. So if any of your employees commits any of these crimes that we have talked about, or the offenses that we have talked about in this cybercrime law, and you as an organization knowingly or unknowingly allows that to happen, you will be held liable as an organization, and you'll be meant to pay a fine not less than 50 million. And the people who will be in the managerial position as per that particular time when the crime was committed will also be entitled to a jail term not less than 5 years. So these are things that corporates need to really understand and be informed about this particular act, so that when it's fully enforced, they know their role to play and the kind of information that they are supposed to educate the employees, so that they don't find themselves in this kind of messes. I think I'll stop there.
Okay. That's a very good. It's a very good discussion, especially when you look at it from a corporate point of view. I will go to our third panelist. So that's once we finished our second panelist. So once we finished with him, then we'll start taking questions. Mr. Kingori Mathenge, my question would be, Miss Nzula Kioko has given us a preview of what cybersecurity laws are in Kenya, and Mr. Chiteri has taken us through the applicability in the corporate environment. Now, could you please take us through how these cybersecurity laws are applicable in addressing the normal Mwananchi's cybersecurity challenges, especially during this COVID-19 period? And also, what areas, in your opinion, do you think we need to have an improvement? Mr. Kingori?
Hello, can you hear me?
Yeah. Did you hear my question?
Yes, I did. Yes, I did.
All right.
Okay. So I'll start by answering your first question. How do these laws apply to the common Mwananchi out here? We've got to realize that is a large group of people with different social economic levels. So it will be, we can't apply the same standard across the board because we have different literacy rate, access to information as well. But the starting point will have to be knowing knowing his or her right, and second, knowing the different offenses under the different cybersecurity laws. In this case, mostly the Computer Misuse and CyberCrime Act. So, and how do we let people understand the different rights guaranteed under the Data Protection Act, the different offenses under the Computer Misuse and Cybercrime laws. So in this we have sort of like a multifaceted approach where we have associations compressing these really bulky information into, say, flyers and something that is easily understood by someone who isn't really interested in all the final legal things, and making it very easy for someone who is out there to immediately pick up on these things and understand his or her rights, as well as the offenses in something like the Computer Misuse and Cybercrime Act. So, and in this case, I'd say, how will they apply currently to people out there, especially with people knowing their rights? I'd say we still have a bit of way to go, since with the Data Protection and Computer Misuse Act, these are relatively new. And I think for something like the Computer Misuse and Cybercrime Act, there is an appeal ongoing about some of its provisions as well. So, in my opinion, I think before the common Mwananchi starts to appreciate these laws, there has to be like some period of it being applied and having cases brought before court with, of course, you're charged with an offense that's listed in one particular act, or someone goes to court challenging, say, company X, organization Y, say, on managing ABC data. So I think that will have to come a bit later. And also we realize with most of these acts, we have stipulations for formulation of say, guidelines. For example, under the Data Protection Act, we'll have like guidelines on what will be the qualifications of a data controller, and we also have other guidelines on classification of data that have to be created so as to make the act itself effective. So it's going to be, I believe it's going to take quite a while for for the individual to, in particular, to feel the effects of that law. But I think how this can be made to go like further or to jumpstart the process is professional bodies, community organizations. Say if it's say on the issue that will be of public interest, like data privacy, and I think these are things that I wouldn't say will be taken up by an individual. It will be better placed to be taken up by a community of or an association of professionals that would say like challenge organization A, company Y about the way they handle people's data, the way they've exposed it, and that sort of thing. I think that will be the first step, especially since these acts are relatively new, and I'd find it very hard for the common person on the ground to actually go to court and they fight for his or her right, especially in this very difficult time when people don't have cash, so there's no way you're going to hire a lawyer, etc. So I think the starting point will have to be through professional organizations, community-based organizations, and the like. So yes, I think I'd stop there and maybe pick up the rest during question time.
Okay, thank you very much, Mr. Kingori. I think we'll go straight to the questions, and can see that people have shared quite a number of questions. I will start with a question on the data protection. I can see this, which I think has been answered, but Nzula, would you be able to just give us a brief preview on the Data Protection Act and how it can apply to cybersecurity, even in addition to what Mr. Kingori has said?
Okay. Yes, we do have a Data Protection Act that was passed late last year. And the Act does talk about classifies data that should be protected. And it's the basic things that it says that the data of an individual should not be shared without their consent or without being informed why the information is going to be released or used or released to a third party. The only instances they can do that is when you have the public interest, protection of public interest. For example, like right now in this COVID-19 period, I think the government is well justified to let us know the numbers that are turning positive every day, because everyone has a public interest in that. And that if and the data that they're releasing, they're not giving us individual information. There's a way that data is being handled such that we don't get to know that XYZ is the one who is sick, but we just get to know that this certain number of people in this geographic area have been infected with the virus. So yes, the Data Protection Act does exist, and it does cover a lot of, should I say, cyber crimes? Yes, it has its own guidelines. Unless there's a specific questions to what you want me to cover under that.
No, I think that should be sufficient for now, because we also want to be brief, because in respect of time. Now, let me just throw another question to you that has been raised here. As a lawyer, could you please comment on the issue of establishing a cybercrime court? Because we've seen situations whereby either there are courts that are coming up for specific sort of crimes or specific claims or offenses or whatever we can call it. So what is your view when it comes to establishing a cybercrime court? Because I think it's something that is really required right now, considering all the cybercrimes that have been on the rise.
I do agree with you. I feel like the cybercrimes are crimes of a very specific and technical nature, and I don't think the courts as they exist currently have the capacity to be able to deal with some of these things without involving experts, like the forensic experts in the investigation, and you know how the trials will be carried out. So I feel like, yes, we do need these special courts. Also, the other thing I also noted about the act is that it has left the investigation of some of these cyber crimes to the police officers. To be honest, our police officers and in our local agencies have no capacity to be able to handle some of these crimes, which are of very technical nature. And I think a lot of crimes of this nature will go unpunished or are unaddressed because of the inability of the police officers to do thorough investigations in these matters. Though there's also the provision under the act that the cabinet secretary in charge of national security may appoint a forensic expert to carry out these investigations, but this rarely happens. And I feel like we do need to have specialized courts, specialized investigation mechanisms to handle these kind of crimes, because they're of a very unique nature, and they do require some technical expertise.
Okay, thank you very much. Now, I'm going to throw this question to the three panelists. Whoever feels that they can be able to handle it, I would be happy to give you the chance to do that. So the first question is, what opportunities are there for lawyers, ICT, stroke forensics, and law enforcement? I think that is something that is encompassing the three of you, so any of you can be able to answer that.
Okay, maybe if I might pick up that. In terms of opportunities for lawyers and IT practitioners, we realize like now lawyers are into law, IT people are into IT, but they don't have the legal knowledge on how to handle most of these cybercrime cases. So I think the opportunity that is actually presenting itself right now is that there will be a time whereby the legal team and the technical team needs to come together, either to work as a team, or also even now the people who are coming up with syllabuses in most of these tertiary institutions, to realize that it's now important for people to understand and marry the knowledge between the technology and the legal knowledge, so that we have somebody who is professional enough to understand both the technical aspect and the legal aspect of most of these crimes that are coming up, so that when it comes to explaining these things even in a court of law, somebody has knowledge of both what the legal aspect think about it and what the technical aspect think about it. And I can give a case in time, if we remember very well what happened during our most recent general election in 2017, where most people were talking about hacking, but they couldn't really understand what hacking was all about. And even now, the legal team, which is well empowered in terms of law to handle such cases, they were not able also to differentiate between what exactly transpired, if actually hacking happened or it never happened and stuff like that. So you find there is no specific individual or specific career in Kenya currently that can actually handle such cases, offenses that have been brought up by or defined by this particular act. And that calls for the government, the academicians, and everyone who is involved to come up with a good syllabus that will be able to define both the legal aspect and the technical aspect to be able to really bring these cases to book.
Okay, anyone who wants to add on to that?
Perhaps I can. I'll talk about what we do as Ashitiva, because I feel like our law firm has had a lot of experience in this sector. We do offer services which in licensing deals, policy development, and regulatory and compliance matters in disputes in the TMT sector. And I think this is one of the the areas which we have helped a lot of clients navigate because of the, like, for example, the Data Protection Act, which came about, and a lot of people who had, and you see, when COVID-19 first of all came about, there was a lot of issues as to what we will do. Will we have our patients go to hospitals? Will they be treated at home? So we helped a lot of clients navigate that area when in complying with the Data Protection Act, and they're coming up with digital health policies, which are now currently being addressed under the Ministry of Health. And we hope that this will soon be passed into law. So there's a lot of opportunity for lawyers, and lawyers can also differentiate themselves and be able to learn and indulge. We can't also just leave this to the technical people in the forensics departments and in the forensic field to be able to only handle these matters, because there are a lot of clients who come to us without knowledge of some simple things like cyberbullying, cyber harassment, and they don't know how they can address, have these issues addressed through the law. And I think it's our place as lawyers to educate and help some of these clients to be able to navigate some of these issues that they will face on a daily basis. Thank you.
Okay. So maybe this is another question that has come up on what's the difference between a technical expert and an expert witness in court, especially when it comes to matters cybersecurity. Who can be able to answer that for us? Nzula?
I feel like that would be best addressed by the KCS, the team on the cybersecurity.
Kingori?
Yeah, I think I can pick that. So I think the difference just happens to be like where is this individual at that particular moment. So I think a technical person becomes an expert witness when they are before a judicial body, whether it's a tribunal, a court of law, disciplinary committee, etc. I think an expert witness is sort of like a situational being who only sort of manifests only before a judicial body. And a technical person can be an expert witness, but an expert witness is not always or is it the other way around? Yeah. So, a technical person can be an expert witness, but not all technical people can be expert witnesses, but an expert witness can be a technical person. I hope that makes sense.
Okay, I think it makes sense. Now, there is also another question that has come up on when it comes to police investigation. I don't know the three of you can be able to handle this. So the question is for either of you to comment on the police contaminating cybercrime scenes when they are the first responders to cyber incidents. What are your comments on that? Mr. Kingori, is that something that you can be able to kind of expound on?
Well, I don't. I'd say personally, I haven't seen it myself. And that's not to mean that it's not there. So I think it will be. I'm not in the best position really to comment about it, but I wouldn't be surprised if it exists.
Okay, I think that's a question that we can probably respond once we get someone who can be able to expound on it. So there is another question here, which has been posed by a student, and the student is asking. He was told by his lecturer that once he does some forensic investigations of a company, and by bad luck he's caught, that he should say that he's a student and he's learning. And by saying so, you won't face many charges. Is this true? Is this something that happens in the forensics side of things?
I don't think
cybersecurity.
I don't think that would be a good defense, because ignorance of the law does not avoid any liability. When you're doing something wrong, you know it's wrong, and criminal liability will apply regardless. But obviously, the first defense is always to deny until you're found guilty. So I don't think it would be an adequate defense in cybersecurity matters.
Actually, it's not actually a defense by that. You see, even the definition of the term student, we have students who are even 70 years. We have students who are 18 years. All of them are Kenyan citizens. These laws are meant for Kenyan citizens. It does not differentiate that because you are a student and you're doing a forensic investigation to a certain company, yet this company was not aware of what you are doing. How can you prove to this company that apart from the forensic investigation you are doing, you are also having access to the information and they don't know where you are taking this information to? So I think the teacher was not very clear with the students on that aspect, because if you are caught and you will face the full course of the law.
Yeah, I think that should be that is a good way of looking at it, because the law applies across the board. It doesn't matter whether you're a student or you're the lecturer or whoever you are, but the law will apply to you just the same as it would apply to someone else. And for someone who is actually in the technology or cybersecurity field, I think this is something that people should be very keen on what you do when you're working, when you're in a situation where you can access someone's private information or information that you're not supposed to access. So there is another question. You wanted to say something? There's another question which is directed at Ms. Nzula. The question is, I realize, okay, I'm just reading it the way it is. I realize that you do use Gmail account when sharing information at judiciary and the implication in it. Is there a plan to mitigate this? I don't know whether you've been able to answer that.
I'm not in a position to quite answer with regards to what the plans the judiciary has in place. I guess we would have to direct a question to the right sources and maybe find out what their plans are, because I'm not aware. And what would be the problem with using Gmail, if I may ask? Because I don't see any issue with that.
So probably that is something that the technical people would be better placed to answer, especially when it comes to the use of Gmails for official accounts, which can be a form. We can do that in another webinar, and I think we've already done something like that before. I will share the details on the webinar once I find the link, and then you can have a listen on all that.
But also, Rehema, maybe just to add something on that. Gmail is an international company. Google is an international company providing mail services through Gmail. So I think the use of Gmail by itself, we have the premium use of it and the normal free use of it, the way we do it. So it all depends with the kind of arrangement that the judiciary, if indeed they are using Gmail for their for official communication, it all depends with the kind of arrangement and the kind of contracts or other agreement they have in place with Google as a company in terms of confidentiality and disclosure of their confidential information that goes through Gmail. Just like you might be able to use any other service provider to provide you with data services for your organization. So I think I leave it for the contract that is in place, the agreement that is in place, the NDAs that were signed with Google as a company. Maybe if they decided as judiciary that this is the company that we need to go with, I think that plays a role in itself. We need not to look at it like the way a normal Kenyan will just open a Google account, a free account, whereby you do not pass any responsibility to Google as your service provider in case of breach of contract that you have with them. So I think that is how we are supposed to look at it. What is the arrangement? What is the agreement that is in place between the judiciary and Google as a company, if indeed they are using Google services for their official communication?
Okay, that has been noted. Now, there is the question that I had asked about police contaminating scene, and there is one of our participants, Kwena, who would like to expound a bit on that. Kwena?
Hi, Rehema.
Hi.
You can hear me?
Yes, yes.
Now, in regards to police contaminating scenes, probably when you respond as a first responder, we normally, every police station, there is normally what we call crime aid officers. And these crime aid officers are on standby 24 hours. They operate on a 24-hour shift. So in case there is a scene and you call or rather need police assistance, the crime aid officers will always be at the scene, and they do not attend to the scene. Their work basically is to make sure that the scene is protected until the relevant personnel arrives and they hand over. You will see whether it's an accident, whether it's fire, whether it's breaking, whether it's whatever the nature of crime that crime scene that it is. There's always a crime scene officer known as first aid. A crime aid, and there are normally two or three of them in every police station. So the possibility of a crime scene being contaminated is very minimal. However, before the crime scene unit was established, there used to be, the police used to use what do they call them? The normal cameramen. So that's where we had quite a number of cases going to court, and we find that the evidence is a bit contaminated, but it's not contaminated from the police point of interrogation. Maybe if answered that well, or if there is need for further clarification in that.
Thank you for that. I think that gives us a bit of light on how that works. So thank you very much.
Okay.
Now we've been talking about the cyber security laws, the applicability to the kawaida mwananchi, and also in the corporate environment. And we've also talked about all the offenses that are in the Computer Misuse and Cybercrimes Act, plus other laws that deal with the cyberspace. Now, Ms. Kioko, there is this issue that we have where lawyers and the IT people and technology, it's like they do not mix especially when people take matters when the offenses are taken to court for prosecution. Now, there's a question that has been asked, and the question is, why can't our lawyers take initiative to learn the basics of cybersecurity and technology-related stuff? Because it becomes very hard to interact. You've gotten the question?
Yes, I have. Some of us are actually learning. I don't know who these lawyers are who are fighting with technology people. You know, when you don't know something, the best way to go about it is learn about it and see how you can add value in that space if you want to be in that space. So as a firm, we have been very cautious about learning about cybersecurity from the experts, and we've engaged some of your services in this learning process, and we are hoping that at the end of the day, most lawyers will be well equipped, equally equipped, or at least, so that we can be able to coexist in this economy. Because I mean, everybody needs everybody. We can't work in isolation.
Okay. Thank you very much. Yeah, so I'm also a lawyer by profession, and I think it's more of an initiative for the lawyers who really want to get into the technology space to find ways of getting to know all these things. And for example, the way we've established the Kenya Cybersecurity and Forensics Association is to bring all those experts together, to bring the lawyers, bring the law enforcement, bring the technology people, just bring all of them together to be able to move forward together. Because I think that's what is needed now, because everyone now is using technology and there's no escaping it.
Yes, that's true. I agree with you totally.
The other question is, and I think this one also goes to you, I don't know whether it's something that you might have touched on, but could you briefly comment on the effect of cyber laws in relation to privacy violations and censorship?
Violation and censorship.
Yes.
Okay. I think I did deal with that a bit in my presentation when I was talking about when I was commenting generally about the act and what I feel has been left out. I feel like the act has tried to define terms such as fake publications and things like publication of false information and hate speech, and these have been broadly framed. And my worry is that such blanket provisions may lead to dumping down of free expression, and citizens may even self-censor, not sharing different opinions or views because they worry that this will somehow contravene the act. So my opinion, I feel like these definitions that have been given in the act need to be narrowed down to be very specific and clear, because as they are, the definitions are very broad and are open to anyone's interpretation. And this may make a lot of Kenyans, people feel like they are being censored, so to speak.
All right. Thank you. Thank you for that. Now, we had this question on the use of Gmail by the judiciary. Kenyan, are you there?
Hello, Rehema. Yes, can I answer something on that?
Rehema, I'm here. Hello, Rehema.
Yes. Proceed.
Okay, let me do away the mask first. Okay, on the question of the use of Gmail, remember we've always had these webinars with the judges, the magistrates, and all, and it has always been a question all through. But the last time the answer we got was that not all these judges do not have their .ke emails. But then the problem that arose, this is courtesy of what the president of Kenya Magistrate and Judge Association said, that at the moment there was a problem with their, I think, servers and something of the sort. So most judges and all that reverted to their Gmail accounts, and you and I know for sure we love our emails, more than these .ke and the likes. But know that they do not have this. So what basically I think needs to be done, or which I know with the pressure coming now that even now the online filing platform and all that, is a lot of pressure and a lot of works it's a great concern, and I think all shall be well. That's what I can say for now.
Okay, thank you for that, Kenyan. Kenyan is our chairman at the Kenya Cybersecurity and Forensics Association. Now, Mr. Bernard Kiema would also want to add something on that. Mr. Kiema?
Yes, Rehema, thank you for giving me this time. I shared this question because the last time I saw judiciary was exchanging the information through the Gmail, and you find that hello, can you hear me? Hello.
Yeah, we can hear you, but you're breaking. You're breaking.
Yeah, I joined you outside the country. That's why I think the network is a problem where I am.
Yeah, but we can hear you.
I think. Thank you. So I was concerned about how judiciary personnel are exchanging the information, and maybe some of them is very confidential using the Gmail account. I was expecting that they can seek the help of ICT authority, so that they can have the government, like the person who has spoken about the government server, their emails can be generated through the government server, so that information can be shared through the government server, not something which is being held somewhere else. It's an issue of security concern with regards to confidentiality and greater information.
Okay, noted. And thank you.
So it is my wish that not even judiciary alone, even all the government offices, all the government personnel should share information concerning let's say information concerning government affairs through the government-dominated servers. And I hope you are in a position to maybe to seek out about this on my behalf, please.
Okay, that has been noted down. So I think we'll now take closing remarks from the three panelists. I can see that it's already 7 minutes past 8. Who is going to start? Can we start with you, Nzula Kioko? Closing remarks. Nzula, are you there?
Yes, I am here. Sorry for
yes.
that. I think I'm having issues with my sound. Now, what closing remarks? Well, the Cybersecurity Act, it does exist now, and we have some level of governance in this sector now. We're just hoping that the government will set up that National Computer and Cybercrimes Coordination Committee as soon as possible, so that they can lay down the guidelines. And where companies are struggling to figure out how to go about some of these issues, they can always reach out to lawyers, I'm sure, and these forensic organizations that are here who deal with some of these issues and have great expertise. They should not be afraid, and they will get the assistance that they require. And thank you so much for this opportunity, and I hope we'll be interacting a lot more in the near future.
Thank you. We really appreciate your presence. Mr. Mathenge? Kingori?
Yeah. So
yeah.
my closing remarks will be there's a lot in terms of educating the masses on the various legal statutes, and unfortunately it's a huge burden on the common mwananchi out there, because reading a whole act it can be really tiring. So I think this is where professional associations come in collaboration with other groups, whether they are educational groups, community-based organizations, and they like to sort of simplify this information, and as well as collaboration via the various forms of media, whether it's social media or traditional media via radio or TV. So I think that has to be the first step before now we can move into now the common mwananchi defending his or her rights on data privacy, because I believe you can't fight for rights that you're not aware of. So I think we have to start from the point of making the information easily accessible to the largest group of people possible.
Okay, thank you for that. Mr. Chiteri.
Yeah, from my side, I'll close by saying that this is already law, and for it being already law, any person, whether in urban centers, rural areas, whether educated, not educated, you are a Kenyan citizen and you are governed by the Kenyan law, and this is already law. So it is your responsibility as a Kenyan to find out all these centers where you can get this information. Be informed about the Computer Misuse and Cybercrime Act. Know what it says. Don't be ignorant, because when you go before the court of law, ignorance will not be used as an excuse for the crime that you committed if you're found guilty for this particular law. But in all, having said all that, also the government of Kenya through other community-based organizations have a mandate to provide enough civil education to their citizens to understand that this is good, this is illegal, this should not be done, or this can be done, so that people should be able to know where to draw the line. So with those few remarks, I really appreciate everyone who attended, and thanks for the opportunity. We hope to meet again in future.
Okay, thank you very much. We really appreciate your contribution to the discussion. I've shared our social media handles on the chat box, so that you can follow us and ask any more questions that you would need to. You can also, for the panelists, you can also put your social media handles so that anyone who has a further question, they can be able to reach you. And yeah, I think we had a very interactive and fruitful discussion, and it was very seamless. Technology decided to be on our side today, so I really appreciate that. And thank you everyone who made time to listen to us to this webinar, and it's my sincere belief that you've gotten something out of it, something of value, and you're more aware of the cybersecurity laws that are in place and their applicability on your day-to-day life and challenges. So I think it would be time to close this webinar, unless there's anything else that can be said. And I am also being informed that this webinar is being recorded, and you can access it on our social media handles. You can access the link there. So yeah, go and check out the link there. So thank you everyone, and have a good evening.
Thank you, Rehema. Have a good evening too.
Thank you, Rehema.
Thank you.
All right.
Thank you. It was a good session.
Thank you, Rehema.